Greetings and welcome to Law and Life. This is a step by Senior Advocate of Supreme Court of India. So Markandeji to share his experience with us and his perspective on the legal issues which are othered in the Supreme Court. Today we will be continuing on hijab imbroglio, which we have already discussed in episode number 2 and episode number 26. In episode 56, which was the last video, we had told our viewers that in upcoming episode, we will put out information available in public domain on two aspects of the case, namely, first, where hijab is worn compulsorily, where it is permissible, and where it is altogether banned, and second, the correctness of binomial case.
Yes, we said that, and with special reference to our episodes 2 and 6. For their benefit, viewers may open and look at those episodes for ampler and more comprehensive understanding.
So, first start with the hijab case, sir.
In modern parlance, hijab is different than burqa, all those things. It's not full, it's just a scarf like object, which is worn over the head and around the neck. So, uh, the fuller versions are called different by different names in different countries like abaya, burqa, chaddor. In our Hyderabad, it is called gosha. There are so many names. As we said in episode number 2, hijab as we understand in modern parlance was promoted by Pakistan's fundamentalist military dictator General Muhammad Ziaul Haq, uh, particularly amongst the women of his country in the diplomatic service and other places. Uh, we, they who wore Western kind of attire. Now, what has happened is that before the advent of Islamic fundamentalism in the wake of Soviet invasion, veil had been banned and discarded in uh, most of the Middle Eastern countries, that is in West Asia. Muslim countries, you can broadly say, for want of better term. That was because of the lead given by the founder of Turkish Republic, who was a very modern person who and wanted his country to catch up with the West in what we call development. And he banned veil in Turkey. That was mostly in appreciation of the outstanding role played by the Turkish women in the war efforts by sewing hundreds of military uniforms. So presently, veil remains banned in two Muslim countries, Albania and Tunisia. So it is compulsory only in Afghanistan and Iran and Pakistan, and optional in all other countries, including uh, once most fundamentalist of all, Saudi Arabia. It was the most conservative country, but now it has opened up. Trend in all Muslim countries is to discard uh, hijab altogether. So many books have been written, particularly by North African women scholars, denouncing the veil as un-Islamic. In Iran, for the demonstrations against the uh, hijab and other forms of uh, veil are too frequent. And this year they were very intense and prolonged. Now, in several European countries, see Albania, Belgium, Bulgaria, Denmark, France, Latvia, all those countries, hijab has been banned probably because it obstructs rapid identification of women in public spaces. Because on the airport, you have to be very fast. The aircraft is waiting there, and there are so many security measures. So, identification with the veil, while you remove and all that, it takes a lot of time for. So, it's an obstruction in rapid identification of women. So that is why they have banned it. And probably, this is a very kind of violent assertion of the religious identity. So European Court of Justice has upheld the ban on wearing all the religious symbols, including hijab. Now in India, as the consciousness is growing amongst the Muslim women about their personal rights, because they want to be at par with, let's say Christian or Hindu or Sikh or other women, who have, there is more openness. So there is consciousness of that kind of identity. So there is a very strong undercurrent of resentment against the burqa and gosha. But influence in those societies are influence of clerics, religious clerics, is too strong to allow their voices to be heard. And then there is failure of public support to movements against burqa and other issues. So that has kind of snuffed out any possibility of agitation. Efforts to organize Mujahira Burqa Fash by Salma Mahmood, the founder of Al Khawatin, a Muslim organization of women, got foiled because not a single chief minister was willing to give, police protection to the activities of Al Khawatin. Can you imagine late Mr. Mulayam Singh ever, getting out of the influence of Muslim clerics? He he kind of backed, the most fundamentalists of them. So these are some of the problems.
Yes, sir. Now about the overruling of by Emmanuel case, sir. What you can tell about that, sir?
Yeah. So here also, for fuller appreciation of this aspect of the case, I would say that viewers should uh, open episode 6, uh, and also another episode, I forgot the number, on fundamental duties. Maybe it's the same, maybe. So Vijay Emmanuel's case is wrong insofar as it dubs the circular letter of Director of Public Instruction as executive order of departmental or departmental instructions. See, the court there failed to see that the state legislature of Kerala had passed the Kerala Education Act. In exercise of the power to frame rules, the state government had framed the rules called the Kerala Education Rules, which were in the nature of delegated legislation. So, under that delegated legislation, Director of Public Instruction is a public authority under that act and its rules. So, he is clothed with power to issue orders and directions. Now, those orders and directions are therefore in the nature of subordinate legislation to give effect to the provisions of the act and rules. So, it is wrong to call them, executive orders or by whatever term the Supreme Court has called it. The circulars issued by the Director of Public Instructions in exercise of his power derived from the Act and Rules is therefore law within the meaning of clauses 2 to 6 of Article 19 of the Constitution. This is an important aspect which the court has overlooked. Then, secondly, the court also did not consider the national anthem. That national anthem is a patriotic song, It has nothing to do with religion. It is not from any Vedas uh, or any other religious book. It's a uh, it's a song, for which Rabindranath Tagore got the Nobel Prize. And Rabindranath Tagore's songs, are national anthems not only in India but also in Bangladesh and Sri Lanka. So he's credited with, writing, or those countries have adopted, his songs as their national anthem. So India, Bangladesh, Sri Lanka. So it has nothing, it has no religious connotation whatsoever. It is not from Vedas or Shastras or Upanishads or any other religious book. It's a song by Rabindranath Tagore, which has been adopted by the Constituent Assembly as the national anthem of India. So there is no religiosity about it at all. Now, the Supreme Court also did not consider that, therefore, that being a patriotic song, there is no religiosity, therefore, there is no question of infringing Article 25. How can a patriotic song ever, infringe religious rights of anyone? Uh, One more thing the Supreme Court did not do, and that is not, it did not consider the cascading effect of its judgment on the rights of other students who were, singing the national anthem. So just imagine, some are exempted, others have to sing. This is not a right situation.
Yes, sir.
One more thing is, uh, the Supreme Court should have correctly interpreted and applied the provisions of Article 51A in the manner it deserved. Uh, See, if the law made by the legislatures, which are creatures of the Constitution, can create restrictions on fundamental rights, then fundamental rights guaranteed by Article 15, Article 19 and 25, so could a provision like Article 51A per se. For example, so many duties are there. Duty to, let us say, let's take the example of duty to serve uh, in the event of any emergency like war. So, if you say this is voluntary, then every person, at least person belonging to Jain religion, can say, my religion says ahimsa. I will not go in the army. So this is not a correct way to interpret. There has to be comprehensive interpretation of Article 51A. Uh, so this is one example that, in the times of war, when there is conscription, then a Jain boy would say, no, I will not go. Able-bodied Jain boy who is required to fight for the country, he will say, no, I will not go. My religion says ahimsa.
Yes,
So
sir.
this kind of thing can't, when everyone has to, if you can't stand for 40, if you can't salute the national anthem and stand or sing that song for, let us say, 50 seconds, then what can country expect of? So this is
Sure.
my,
Surely, sir, it's a duty of every citizen to respect the national anthem and stand with it's a morality of every citizen to do so. And with that, sir, we will be ending here Hijab Imbroglios and Pajus Emmanuel's case. Thank you, sir, informing all about it. You can watch the episode number 2 and 56 for more reference, which will be the link provided in the description box. Thank you, sir, and thank you everyone for watching this video. That's all for the
thank
day. Thank you, sir.